all reasons, it's just much easier. We will go on the record in the matters 25 CF43, 25 CF42, State of Wisconsin versus Kenneth Acterling and State of Wisconsin versus Stephanie Acterling. Appearances are, we do have the state appearing through District Attorney Kevin Schmidt in person. We do have Kenneth Acterling appearing in person with his counsel, Michelle Erdman. We have Stephanie Acterling appearing in person with her counsel, Charlene Perrin. We're set today in this matter for the final pretrial. This is the court's drop dead date. We do have a speedy trial currently set for 5 days to begin on December 1st, 2025. There are certain things that we do have to handle and take care of here today. As this is the final pretrial, I'm pulling up the court's scheduling order in this matter so that we can make sure that we go through everything, because it needed to be, everything needed to be done according to the deadlines provided by the court in the scheduling order. I'm going to start with Ms. Perrin. Can you please provide me an update on whether or not you believe that this matter has reached an agreement or is close to reaching an agreement, and you just need a few little moments or other moments to tweak it?
At this point, there is no agreement.
All righty. So anything else that you can update me with regards to your case? Because according to the scheduling order, we do have certain dates that we have to abide by because, again, this is a speedy trial and we need to make sure that we are ready to go.
So I filed our motion limiting, I believe. I filed a letter about our expert, but then
I reviewed that with the DNA expert. Now you're pulling that back. I reviewed your motion in limine. I didn't, in your motion, didn't see anything too different.
Nope.
Okay.
Nope, there really isn't. So, no, Your Honor, there's nothing at this point that I think I really need to raise with the court.
Excellent. Thank you, Ms. Perrin. Ms. Erdman, I'm going with you second because you did file your motion in limine as well as your motion objecting to a lay testimony by I don't even know what kind of the MOCIC. I don't know what that stands for, but that MOCIC employee. And so I have reviewed all of them, and this is the date and time to discuss these matters so that we are all prepared to move to trial. Because again, this is my drop dead date. That means the court will not accept any agreement after this date. That means that if we move forward, either the defendants must plead guilty to all of the counts that are charged against them, or the state must dismiss those counts or some of those counts outright. Otherwise, the matters will proceed forward to a jury at that time, if convicted or for the trial, and then we will proceed later. So Ms. Erdman, this is your time to make any arguments as to your motion.
Judge, I filed both a motion in limine and then a separate motion addressing, I guess, what could be kind of framed up as lay testimony in introducing cell phone site data. I think that's probably the bulk of what would be addressed. So I'll start there. And essentially, I think there's a couple of concerns. So the way that this case came on was a speedy trial demand that I don't know that anyone, myself included, was expecting. So we've all been working hard to comply with the deadlines. We had a conference and the court gave us a scheduling order. And in that order, I noted that there was particularly something referenced about making sure that Daubert hearings were heard timely. I kind of gave it some time waiting for the state's witness list, anticipating that I wanted to file one, but didn't see the state's witness list forthcoming. At that point, I just wanted to put everyone on notice, hey, I want to make sure that everyone knows this is an issue. And I think the Daubert issue really came down to whether or not the correct person would be seeking to submit the information relative to cell phone, and kind of based on a lot of the technicalities that are involved, things like whether or not the whether or not the cell phone sites, are on a hill, and how that can impact the reception, and the location isn't exact. And there's this concept where a pie chart is typically drawn, which is kind of like a 90-degree angle, and how that really isn't necessarily meant to be interpreted literally, kind of thing. And so I put that Daubert motion out. The state rightfully pointed out I had an error in my motion that had listed I recycled a motion, so the names listed were nonsensical. They weren't applicable here. And I acknowledge that. That was my mistake, and it was just a sloppy mess. And so the motion was out there. The state then responded by email. I don't intend to use an expert. I expect that this will come in under lay testimony and cited a case. And so it was only, I think, 2 days ago or yesterday, I can't remember when I was working on it, that I was able to really sit down and digest the issue. So I apologize for the tardiness. But essentially where I've landed, Your Honor, is that it's an unsettled standard in the state of Wisconsin, whether or not expert testimony is required when introducing cell site data. And the case that was cited by the state is US versus, or state versus Cameron. That's 2016 WIS app 54. And that essentially adopted an unpublished opinion, state versus Butler, 2014 app, AP 1769. State versus Cameron was a case fact pattern where there was a stipulation as to the accuracy of the cell site information. So the data from the cell phone provider was already stipulated to, and it was literally a plotting exercise on a map of taking the latitude and longitude coordinates and applying them to a piece of paper. And in that case, the courts held that it doesn't really require any kind of specialized knowledge, and that it doesn't take an expert to make a map using cell phone tower data provided by the phone company. That was the holding in that case that the state was purporting to rely upon. And so as I've set forth in my motion, there's a couple of things. One, this is not stipulated to information. And two, the attachment that the exhibits that I attached, exhibit 1 is a copy from the provider, it's AT&T in this instance. And there's a couple of cautionary disclaimers at the top. The results provided are their best estimate of the location. Please exercise caution in using these records for investigative purposes. Location data is sourced from various databases, may cause location results to be less than exact, right? So that was kind of the place where we started. And then at the bottom, it's disclaims that it's proprietary information. That's so it's using a compilation technology that they're not willing to disclose to the outside public world. And so, Your Honor, we'll see on exhibit 2 is the data that was put together by the analyst from, or I guess I'm not sure of her position there, but the MOIC person out of, I think it's Missouri is where the lab is located. And I just want to, I guess, call to attention the purported caption or heading of this: all cell sites for calls, data, SMS messages, and time in advance for this phone number for this time period. That's what the exhibit is purporting to show. And then there's a pin where the quote unquote burglaries occurred. So that's noted in the top corner. And so then if you scroll down, there's a second pin that's been added, and that's the area frequented by subject. And if you kind of look between the two, right, if you start at the top and then look to the bottom, the area frequented by subject is not supported. It's not supported by the cell site data. So that seems to be kind of a hearsay or that information likely came from an alternate source. And then as it goes forward, they've applied the familiar pie shape kind of notations, etc. And it goes into even, broader strokes that way. So what the state, I believe, is saying now in the response that I saw is, well, I can still do this, right? I'm going to just use the AT&T witnesses that weren't disclosed yet, because I reviewed the second witness list filing that was made within the last week or so. There's still no one listed from AT&T to introduce business records, such as the cell phone location data. But the state's saying, I can get around this. And my expectation is I would just call these folks, have them say, this is our business data, this is the detail. And then we've simply just done a mapping exercise. That's how the state's asking to introduce this. The business record obviously will be subject to cross-examination, especially as it relates to the disclaimer at the top. But I think I would pose to the court, even if we've got someone sitting here from AT&T who says that we at AT&T pull latitude and longitude data using various sources that we consider proprietary, but they're databases, and we use that to compile this. And then the state is permitted to take on that mapping exercise. At what point in this process do we hear from someone who can say, but wait, this is something that's next level, this compiling of data at the source involves certain levels of expertise, certain levels of software. Here's how it works, here's how it's explained. And this is why what you're seeing on the map looks the way it is. And I'm sure the state will be very quick to say, but judge, if the defense wants that kind of information to come before the court, then it's the defense's burden to provide that technical detail. I simply want the ability to take what has been deemed less than exact, that's the words that they use, less than exact data from AT&T. I just want to take it and put it on the map, judge. And if the state doesn't like, or if the defense doesn't like it, then they should bring in someone to tell me why I can't. And I think that it's something that the court really should be aware. The federal courts have held a variety of different ways on this. It's not settled law in Wisconsin. I did give you the cites in my motion that there were some people that were pretty vocal that this needs to be introduced at an expert level. That's at the federal level. But I will also say, in certain instances, under the correct amount of correct circumstances, where there's already either a stipulation as to the accuracy of the data, or at the lowest level, there's just not a lot of contention, that the courts have been open to allowing people to do kind of, I guess, what amounts to a mapping exercise, right? Take and plot, location A here, location B there. But I guess the confidence of the data to begin with this less than exact disclaimer, and then taking it and applying it as they have on Exhibit 2 and saying this represents all data, all sites, all cell sites for the calls, right? And P.S., sometimes calls bounce off of one tower to a second tower to a third tower simply because of the way, Your Honor lives in the Northwest. You understand cell phones are not, precise and exact. They don't necessarily always work in certain areas. There's some areas that are better than others. It has to do with topography, etc. So I think it's something that we just, I guess, need the court to be mindful of what's been done in the past. Our urging would be that the court say that this, based on this level of detail, without someone coming in to interpret, it's just not sufficient to be introduced in this manner.
Thank you. Ms. Perrin, I know this is not your argument, but you are a co-defendant, or you represent a co-defendant in this case. And so your opinion on this matter, your statement as it relates to your client is important.
Right, I would join Attorney Erdman in her argument, and I can file a motion as well.
You don't need to file a motion as well. I think I will take this as an oral motion to concur and side with the arguments made by Ms. Erdman.
Yes, and she did tell me about it, and we did talk about it the other day. I haven't had time to file anything, but I did review the federal and the state cases. I agree, the federal cases do support not allowing the state's witness to testify about this, and I agree that this Wisconsin state law is not settled in this area.
All right, thank you. Mr. Schmidt.
I have two main thoughts on this topic. One, I don't know how the court could accept the arguments by the defendants without just completely eviscerating everything Cameron stands for. When I look at paragraphs 25 and 26 in Cameron, they specifically address this exact argument. This was the argument put forth to the Cameron court. They talked about what the experts said about accuracy and reliance and mapping. And in paragraph 26, the Cameron court says all that stuff, it goes towards the weight of the evidence of the cell phone location mapping, not to the admissibility. So I think what the court is hearing right here is not an argument that this evidence is inadmissible for some reason, because they are admitting it's layperson testimony. They are not saying this is Daubert. Then this argument is an argument for a jury. It should be, hey jury, the top of this document that Mandy Britton used says it's inaccurate somehow. What does that mean? State didn't present that. The weight of this evidence is lesser. This doesn't bear towards credibility. And in fact, Cameron cites positively towards courts accepting cell phones in 2016 without a Daubert hearing or mapping data on it. It's 9 years later. There isn't a single person in this courtroom who doesn't have a cell phone. There isn't a single person anymore who doesn't know how cell phones track location through cell towers to satellites. This is not something that is needed for expert testimony anymore. I think you'd have a better argument saying that juries would need expert testimony to understand a landline more than they'd need to understand a cell phone, just because of how times have changed and the ubiquity of cell phones in human life, and specifically with like the location data. Who has never used Google Maps or something like that? When a person alleges that something requires an expert, what they're actually alleging is that it is something that requires expert testimony. That is, the jury needs an expert to interpret or understand what it is, how it was collected, why it exists, or anything like that. This isn't that kind of data anymore. People understand that the GPS collects your location data. If the defendant brought like an expert or something to testify to that, it would just be an attack of the credibility of evidence. It wouldn't be like, this shouldn't come in because I found an expert who says this is inaccurate and people shouldn't rely on it. And that goes again towards, we should be talking about admissibility, not weight of evidence. Second, and this goes towards like a broader complaint I had about all the motions in limine filed by Mr. Acterling, is they're filed yesterday. I had minutes to hours to respond to any of these. I'm not forfeiting that I think Cameron is abrogated or overruled or language in it is dicta because of federal cases. I think that the cell phone data comes in as a certified business record. Mandy Britton can map it based on Cameron. And if they want to attack the weight of evidence because there's no one from AT&T to explain how it's collected, that's up to them. What I wrote in there about all of these issues being solvable if I lost a hearing on any of these related to the timeliness of the motion. The defendants, I don't think it's reasonable to play dumb and say, I don't know who they're going to call until they file a witness list. They've had this information for months and months and months. It's referenced in the criminal complaint. It's unreasonable to think I'm just not going to use evidence I've given them or I've referenced in the criminal complaint. And the reality is I'm kind of being thrust into one-day notice motion hearing right now. And if the court rules against me in normal course, what I do is, well, the solution is I just call someone from AT&T and then I still get it in. But the problem with, requesting a speedy trial and then doing the motion eliminate the day before the end of the deadline per the scheduling order is I'm kind of just prejudiced and a victim of brinksmanship, really. Like, a speedy trial is not intended to force a shotgun wedding where everyone has to go to a trial where people are unprepared or who've taken reasonable deliberate actions, which I think the state has done in this case. And the way they know State v. Cameron is I notified them and said, I don't think this is expert testimony. I let them know that in case they did want to challenge it in a timely fashion. So I think the court should find it does come in through State v. Cameron. And yeah, and if we're just addressing this, then I assume we'll move on to the other things. Thank you.
All right, thank you. Brief reply or rebuttal?
Just, I guess, I do acknowledge that a day for Attorney Schmidt to prepare is unfair. Like, I'm not trying to push things. I mean, so, I mean, if he needs some time to research, review, but I still maintain that the court, I think, even if I was ineffective in bringing this at the last minute, it's certainly something that warrants review.
Well, I appreciate that. Thank you. And Ms. Erdman, I do not, even though there could be an argument against that, and there is an argument from the state that with regards to timeliness and the scheduling order, et cetera, it's well-versed in case law that courts must be a little bit more lax when it comes to scheduling orders in criminal matters versus civil matters. In civil matters, I can be cutthroat. Nope, you did not follow that to the letter. So absolutely no, even case dismissed, whatnot. But this is a criminal matter, and I have to look more and to put more weight on the defendants and their constitutional rights and the need to be heard. And that's exactly why we are having the hearing today. And I do understand that it puts the state in a little bit of a tight spot to have to argue it here today. But I'm going to tell you, state filed a motion, and as you can see, I review and I read things. And they were able, the state was able to make a pretty thorough argument in a brief amount of time. I think after receiving your motions, it was filed within an hour after that or something, bing, bang, boom. So I think the state has had the ability to be prepared. And so this is adequately in front of the court here today. If by chance either side would like to have an argument after the fact, even though this is a final pretrial, the drop dead date, the court will still allow that in writing. However, the court is more lax as it relates to the deadlines in the scheduling order in a criminal case. And that's where I am, and that's where I'm going to be. So even though it is past the deadline, it is still ripe to be heard in my review. But however, although I do understand your argument and I do understand the supporting argument with Ms. Perrin, I am denying your motion based on State v. Cameron. I know that it may be undecided or nothing set in law, federal versus state, but State v. Cameron, at least in my court, that is what dictates, and that's what rules. And this will be an argument for the jury. And that's where you can present your own witness. You can, I'll even permit the defense to find and locate an expert to testify at the speedy trial, even though my scheduling order states that an expert report must be submitted within 30 days prior to trial. I believe that in a case like this, and having the witness that the state has with the arguments made by defense, if by chance you happen to believe that you find an expert or even another lay witness that can testify, a report can be provided along with the deadline for the witnesses. And in my view, I do understand that there is a holiday, that there is the Thanksgiving holiday there. But in my count, I can see, unless objection by the state, that a deadline for witnesses and or then any report could be November 21st. Granted, it doesn't give much time for everybody to be prepared, but then I believe it's more fair to the defense to be able to find another witness if you wish, or to be able to, then you know as of today what questioning you can line up to question Ms. Britton when she's on the stand to cross-examine her and her knowledge of the mapping as well as the other issues as you see related to that data.
Judge, I just want to, I'm sorry if it's not appropriate, but I just want to, so she's not been disclosed as an expert. Her credentials have not been
She is not an
set
expert.
forth. And so I would just argue to bring forth the information that's required. I mean, I can ask for the questions, but our position remains this should be handled differently. Thank you, Your Honor. I appreciate your ruling.
And you can, and I understand where you're coming from. You're free to ask her whatever questions you would like to ask her while she's on the stand. But in my reading of State v. Cameron and in the analysis, I don't find her to be an expert witness, again, according to what the parameters of State v. Cameron. So that's where that is. Mr. Schmidt, is there anything you would like to state with regards to my order?
Just if either the defendants plan on retaining an expert, that'd be the only circumstance in which I would get an expert. So I just ask if they do plan to do that to let me know ASAP, and then just whatever the court's deadline for the defense apply to me too. If, because I assume these are both public defender cases, if that timeline is not possible because of how the public defenders do their expert retaining things, let me know ASAP.
Well, and here's the thing too, and I'll throw this out there. I know that this has been requested as Speedy, and I can't remember if it's Mr. Acterling or Ms. Acterling that requested the Speedy. However, that if this is such that in discussion with your counsel, you believe that you really want an expert, and that is something that you wish, even though this is the final pretrial, I will allow you to withdraw your Speedy, and we can get it set for another very quick turnaround for a trial. But I want you to be able to be prepared in presenting your case, because this is a very serious case with serious charges and potential serious ramifications. So I would allow you to be able to do that without any penalty or anything of that nature, okay? So I don't know. I'm seeing some discussion between Ms. Acterling and Ms. Perrin. I don't know if that means you would like to have discussion amongst the four, although you're completely separate cases, separate paths and separate wishes and desires, but
Could we just have just a very brief moment? And it won't be, I don't know how long does the court have? Are you able to give us a few minutes?
I'm running way past and past calendar, but here's the thing. Even though I do not like to do that, I'm not other courts, I do not like to do that. This is a serious case, and I want the defendants to feel comfortable in proceeding, because I'm going to be blunt, your lives are on the line, okay? Serious case. So I want you to be able to feel comfortable in where you are here today and where you are with your attorneys, okay? And where you are with the facts and the evidence and the witnesses that you have. So I am prepared to be able to leave and have everybody else vacate the courtroom, and except for law enforcement, I cannot have him vacate. But can you please raise your right hand? Do you swear to tell the truth? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Anything and everything that you hear inside this courtroom that pertains to this case, you are not an attorney, but do you swear that you will never, ever state anything of what is said in this case at all?
I do.
Never, ever.
Never.
All right. So that's the best I can do. I'm sorry. So I will excuse everybody for a brief moment.
Can
will
we
be
just say
back.
10 o'clock?
Do you need 10 minutes?
Judge, I had a couple of points that I just felt were.
10 minutes are
relevant. I
fine.
don't think I need 10 minutes.
I can give you
If you've
until
got
10
minutes,
o'clock.
we'll take 10
I'll give you until 10 o'clock.
Okay.
Yes. Fine. We're all good. This is very important, and I want everybody to be comfortable. So
Yeah.
I'm just letting them in so I can let them know what's going on. Everyone who has just been brought into my courtroom, I want to offer my apologies. We are running behind. We have a very serious case that we're handling, some serious issues. And so we will get to your cases as quickly as we practically can. We're wrapping it up right now. All right,
No problem,
back on the
Judge.
record. Back on the record. Back on the record, same appearances as previously noted. The court has allowed attorneys Perrin and Erdman to have a confidential conference with their clients, Mr. Acterling and Ms. Acterling. Again, for the record, we did have law enforcement present in the courtroom during that time. He was placed under oath and he was sworn to keep everything confidential, and he may not disclose it to anyone or there could be contempt of court, yada, yada. All right, so Ms. Erdman, do you want to update the court right now, please?
Judge, I am not signaling in any way, so we should all keep preparing as we have been. But I would ask the court just for until maybe mid next week to extend the settlement deadline. I am not saying that I'm not signaling. I don't want anyone to read anything into that.
No, nobody's reading anything into that. And I'm going to tell you, I'm a judge. I like to stay on time and I like to stay with my deadlines, especially with speedy trials, because they are quick, and everybody has to do it quick. But with that understanding, knowing that this is something that's going quick, and both of the defendants, you have a lot on your shoulders right now. You have a lot to think about, a lot to digest. I am willing to extend this deadline to next week. No objection? Do you have an objection?
No objection. If you need to contact me, I'm at SPET next week. So just contact my office. I'll get my personal number and be available.
And that's what I was going to say too. I am at a all judicial conference next week, but I will still be reached by all of my staff. And so I will be able to be up to speed on what's going on. We have Veterans Day. I don't know if you probably work all the time. So I remember private practice too. You work all the time. How about a deadline of?
I think Attorney Perrin and I are both going to Milwaukee on Thursday, and you're leaving Wednesday.
My thought was deadline by Wednesday.
Okay, perfect.
Does that work?
Yep.
Because then it works with, so we all are going to conferences. Yay! No work in courts next week at all. Yeah, so deadline by Wednesday. And can I say Wednesday by noon?
Sure.
Does that work?
Yep.
So Wednesday by noon, okay? And so you'll update the court, you'll let me know. And if I'm going to, it's probably going to have or need a response by the court, but you'll get a response even though you'll be in a conference, and then you can let your clients know, call them if necessary. Otherwise, we can set a hearing by Zoom on the 17th if you wish.
We'll cross that bridge if we need it. We'll set something up with Madam Clerk or.
So you know, my afternoon has cleared on the 17th, so I could
Okay.
pretty much facilitate anything on the 17th. And I'm just going to throw this out here. Okay, I'm just going to throw it out here. I'm taking no implications that there could be a settlement, none implications. But if by chance it does, and it can, if it will, or whatever, again, I'm open all afternoon. I have all afternoon. We can argue, we can do a plea.
I've got another speedy trial that I believe is going forward in Polk County that day, but again, we'll cross that bridge and I will try to be as prompt as possible with the court so that we can figure something out.
And well, if you have a speedy that's going that day, I know that it's hard when you have a trial to fit things in. We could even possibly facilitate 12.
Yeah, right.
Or something.
I appreciate your honor's flexibility and we'll stay in touch.
Okay, all right. Did I have a victim say something? I'm muting the victim because the victim keeps making noise, or whoever's identified as a victim. Okay, anything further we need to address, at least at this moment, Mr. Schmidt?
Are you withdrawing the thing about the late discovery DNA?
Yeah, Judge, I filed some motions in limine. I can kind of go through them quick, but I don't think any of them are going to be really long. Number one was a DNA discovery question. I actually am in possession of what Attorney Schmidt acknowledged to be the test. I think it'll be subject to cross, something ripe for that.
Okay.
So I'm not raising issue, and I will say the state was prompt in their disclosure.
So that's withdrawn.
Okay.
And then you had one about Facebook messages or something.
Yeah, the next thing that I think, it's more probably of a heads up. I tend to try to err on the side of getting things before people so they can think about them, state court, myself included. And so we've received downloads, and I'm talking, and law enforcement's paged through them, but I don't even know if they were able to get through everything. There's a lot there,
And I'm
Judge.
gonna interrupt you. I don't know what's all there. I don't get discovery, so I don't know how voluminous they are. I know the ones that have been brought to my attention through motions and those things. Those ones I didn't have issue with coming in. I don't know, again, what's particularly in the other massive communications.
Okay, I'm assuming Your Honor's referencing the things that were disclosed in the complaint, right?
That must be it, correct?
Or did Your Honor get
Um,
information outside of the,
I'm not, either this or Mr. Harrington represented Mr. English, and we had a very lengthy motion hearing in that case too, and I don't know if additional ones were provided in there or not. No, Mr. Smith is indicating no. So whatever was provided in the criminal complaint, that's what I'm referring to.
okay. So I guess, I mean, I'm just making note today. There are things where law enforcement is saying, in their report, I reviewed this information. This is hypothetical. I saw a picture, a photograph of Mr. Acterling. In the same photo was a purple dress. I know a purple dress was taken from a house. It could have been one and the same. Those kinds of things where there's speculation involved.
Well, it's speculation, but open to cross.
I believe that unless the state's here prepared to say that the only cases involved were those that are in the state of Wisconsin. These are Minnesota, or Mr. Acterling lives in Minnesota. Things were located in Minnesota. I mean, I think some of this is potential for other acts, right? So there's a trailer that was located. We don't know where that's from. But to speculate that it was from this, or to somehow say, you know, things involving drugs or something to that effect are relevant.
That is definitely not relevant.
But I think we can address that. I know Your Honor's got a lot going on. So those are just kind of a heads up. I don't have anything specific listed intentionally, just kind of making everyone aware. I view that as other acts. I think that there's, you know, nothing that's been brought before the court saying we intend to build the case that because there's other things that are likely stolen, perhaps stolen from other instances, that they're somehow relevant here. I think the rest of this, Judge, is boilerplate. I tried to underline the things that were kind of unique
The
to
rest
this
I thought was
case.
boilerplate.
So
Yes.
that's all I have.
That's all I had highlighted. Mr. Smith.
Oh, I'm sorry.
Oh.
I have one more final thing. This is kind of an add-on. My expectation, or I guess my hunch, is that Mr. English is prepared to manage his case with a plea. If so, I would ask that all of the plea negotiations, including the disclosures that he's made to law enforcement, be made available to us immediately or as soon thereafter as possible, and that all benefits of any bargain are also disclosed. That's the last thing.
All right. I have not had Mr. English's pretrial yet, but we are going to have that not right after this. I have to quick jump into the quick cases first before I bring them down. Mr. Smith.
Just, I'll comply with what they asked about Mr. English. On the Facebook, if we did a Facebook subpoena, it was only the relevant time for the burglaries. There is drug stuff in there. I don't intend to use drug stuff. I only plan to use stuff related to stealing or preparing for burglaries or talking about burglaries. I am not aware of other burglaries Mr. Acterling has done. I think they're all related to these. If Ms. Erdman thinks that there are statements in there about burglaries or thefts or related to that are related to different burglaries, I need to know what specific statements they are different burglaries, because I would have no way of knowing that. Thank you.
All right. And I
would just argue that if they're not clear enough on their face that they're related to a particular case, then they need to stay out, because we don't, if I have to try to get, or if he's
Well, here's the
trying
thing,
to guess.
you can look through them, you can make your argument as to what, but again, this is in other acts, which should have been done a lot prior to today. And we should have had the arguments and hearings prior today. I am giving an additional week for the settlement discussions, or to update the court as another final pretrial or whatever. But if there are particular ones that you don't think are clear, you can point them out to the court, and the court will make that determination. And I know other acts, and I would know the factors and the test, and we can go boom, boom, boom. That can even occur right before the trial, if that's what we're going to do. Okay, Ms. Perrin?
Your Honor, part of my motion limiting is asking the court for an order that no other acts be allowed, because the state has not filed any motions on that. So I just want to mention that, since the issue has come up.
No other acts, correct, but other, we'll get into the convictions and whether all of that. That's kind of boilerplate, kind of the
Right.
thing, because we haven't gotten here, but Mr. Schmidt.
And that's what I'm just trying to get into is I don't think any of it's other acts. I think it's all related to these burglaries. I have no information of them doing other burglaries. If I did, they'd just be in the complaint. They wouldn't be other acts. So I don't think if that is their position, I need to file another X motion because it sounds like they would be contesting my position and saying, no, these are not messages our clients talked about doing these burglaries. This was them talking about doing other burglaries, which would be on them.
I fully understand both sides here and your arguments. And Ms. Erdman, because we have this additional week, I know it's putting a lot upon you and Ms. Perrin too, because I'm going to guess it's a joint. But to look at those text messages, and if this matter has no chance of resolving, then point those out, your deadlines by next Wednesday as well.
I'm just gonna say that's impossible. Like, we've got 3
I
other
don't-
speedy trials and it's not our burden. And they can come in
But
at
it's my
trial and then we'll
burden.
object.
But it's my burden. It's my burden. I
That's
have to
why
decide.
we Let the court
Then
know
give
ahead
them
of
to
time.
me. Then give them to me.
Okay. Well,
Give me the text messages. I will review them. Give them to me.
That's why my motion, I only just asked which messages are you saying? I don't know.
Because I don't know. I only have the messages in the criminal complaint.
in the-
You want me to make a decision and to decide? I can't unless I have them and I have arguments. And I need defense to give the ones to me that are questionable. Otherwise, give them all. And
Or
then
the
I will
state
review
could
them.
perhaps just disclose what they intend to use and we could go from there. I mean, that way we're not guessing like we've been with the Daubert motion and everything else.
I'm using all messages in which they talk about burglaries or thefts. I think they're only talking about this cases. I have no information they're doing other burglaries and thefts around the same period.
The trial may take 3 weeks then if you're using all messages, just putting that on the
Well,
record.
I'm gonna tell you, I am some trials may take 4 days in one county. You only take 2 in mine.
Right. Understood.
Okay. Anything else? And again, I will state on the record though, I have no problem, and I'm not the jury. So let the defendants know, I'm not the jury. The only way I make a decision on these text messages or Facebook messages or whatnot is whether or not they can come in or not. I don't decide whether or not, you're guilty or you're not guilty or all of those things based upon text messages. So that's why I'm just putting it out there. I have no problem. You want to know what? I have 4 days of, granted, lots of conferences, but I have lots of downtime too. I have lots of reading time. I usually bring the Court of Appeals cases and read them all through there. So I will have time if that's what you would like. Just putting that out there. Again, another thing for you guys to talk about. Okay, we got to wrap this up though. Any last? All right, then we are adjourned. Thank you.
I will come and see you
Leave it. Yeah.
after court. I have one other hearing, but then I will.
I have a
come see
hearing
you.
right now at 10:15.
All right, I have to quick look through. Ms. Perrin, I have you for Weaver.
Yes.
Do I have Weaver? I might have him right here.